これより国際知財司法シンポジウム2020日米欧における知財司法の現在地と課題を開催いたします。第1部の司会を務めさせていただきます。知財高裁判事の真鍋美穂子と申します。どうぞよろしくお願いいたします。本シンポジウムをライブ配信でご覧になっている方へご案内がございます。本シンポジウムの配信は日本語と英語の2チャンネルで行っております。いずれかをお選びいただいてご覧ください。それでは開催に先立ちまして、主催者を代表し、最高裁判所小池博判事よりご挨拶申し上げます。
主催者を代表して一言ご挨拶を申し上げます。本シンポジウムは知的財産に関する紛争解決に携わっている6団体、すなわち最高裁判所、知的財産高等裁判所、法務省、特許庁、日本弁護士連合会および弁護士知財ネットが協力して開催し、これまで3回の会議を重ねてまいりました。本シンポジウムの第1回の会合は2017年、アジア諸国の裁判官、弁護士を日本にお招きして開催いたしました。第2回は2018年、欧米の裁判官や審判官をお招きして開催し、2019年には第3回として、アジア太平洋地域の裁判官、弁護士、警察関係者をお招きして開催いたしました。そして第4回の会合は、再び欧米の裁判官や審判官を日本にお招きして、昨年10月に開催する予定でした。しかし、ご存知の通り、新型コロナウイルス感染症の世界的流行により、開催時期を延期し、開催方法もウェブ会議によるものに変更することとなりました。海外の専門家の方々を我が国にお招きし、直接交流することができなくなったことは誠に残念です。また時差の関係から参加者の皆様には大変なご苦労をおかけし、会議の時間も短縮せざるを得ませんでした。そうした制約があるもと、しかも各国が厳しい状況にあるにもかかわらず、アメリカ、イギリス、ドイツ、欧州特許庁の知的財産分野の専門家の方々には参加をご快諾いただき、この会議を開催することができましたことに心より感謝申し上げます。経済活動のグローバル化に伴い、知的財産に関する紛争は国際化が進んでおります。このような紛争の国際化に対応するため、司法の分野においても他国と連携して国際的な動向や課題を適切に把握するとともに、各国がお互いの法制度や審理運営のあり方について知識や理解を深めることがますます重要になっております。また、新型コロナウイルス感染症の拡大を防ぎつつ、紛争解決機能を適切に維持していくことは、紛争解決に携わっている世界各国の実務家が共通して直面している喫緊の課題であります。このような状況を踏まえ、本日のシンポジウムでは、日米欧における知財司法の現在地と課題をテーマといたしました。そして第1部の裁判所パートにおいては、特許権侵害訴訟における均等論の実情、および新型コロナウイルス感染症の影響下での裁判運営についてパネルディスカッションを行います。第2部の特許庁パートにおいては、仮想事例に基づく進歩性判断に関する議論、および各省審判部における新型コロナウイルス感染症に対する取り組みについてパネルディスカッションを行います。本シンポジウムにおいて各国の実務家同士がこのような課題への認識を共通しつつ活発に意見交換をしていくことは、知財司法の分野における各国の議論を進化させる契機となるとともに、各国間の連携を一層緊密なものとし、新たな時代に向けた知財司法のさらなる発展に大きく寄与する機会になるものと確信しております。また今回のテーマは、知財司法の分野のみならず、より大きな視点から新型コロナウイルス感染症への対応契機とした 民事司法を含む紛争解決の進め方の改善を考えるにあたっても、有益な示唆が得られるものと考えます。限られた時間ではありますが、活発な議論が行われ、本シンポジウムが皆様にとって有意義なものになりますことを記念して、私の挨拶とさせていただきます。
裁判所小池博判事によるご挨拶でした。それではここから第1部裁判所パートのパネルディスカッションを開始いたします。ライブ配信をご覧になっている皆様は、パネルディスカッションの資料として、あらかじめ専用ウェブサイトに公開した均討論一覧表がお手元にありましたら、そちらもご覧ください。最初に登壇の皆様をご紹介いたします。パネリスト、日本、大高一郎知財高裁所長、熊谷大輔知財高裁判事、中村合同特許法律事務所パートナー、相良百合子弁護士、模擬裁判では被告代理人を務めていただきました。イギリス、コリンバース高等法院判事、ドイツ、クラウスバッハ連邦通常裁判所判事、アメリカ連邦巡回区控訴裁判所のシャロン・プロスト長官は、現下の状況によりご参加いただけないことになりました。アメリカからは、ドーシー&ボイットニー法律事務所パートナー、ポール・マイケル・ジョン弁護士にご参加いただきます。モデレーター、高橋彩知財高裁判事、アンダーソン・毛利友常法律事務所パートナー、城山康文弁護士、模擬裁判では原告代理人役を務めていただきました。それではモデレーターの高橋判事、城山弁護士、どうかよろしくお願いいたします。
それでは早速、裁判所パートのプログラムを始めます。まず、今日取り上げるテーマについてご説明します。前半には、特許権侵害訴訟における均討論の実情について取り上げます。ここではすでにウェブサイトにアップしております模擬事例及び模擬裁判を題材に、各国の均討論について議論をしたいと思います。模擬事例は日本の視聴者の皆様にはおなじみの中空ゴルフクラブヘッド事件の題材にしています。後半では新型コロナウイルス感染症の影響下での裁判運営について取り上げます。約100分のプログラムになりますが、どうぞ最後までお付き合いください。Good morning and good afternoon to the speakers abroad. Mr. Shiroyama and I are the moderators of this session, and we are honored to be moderating this panel of outstanding IP practitioners from Europe and the US. I'd like to express my greatest appreciation for being with us today, especially to Mr. Michael John in Seattle, where I know it is very early in the morning. 均討論の議論を始めるにあたり、模擬事例についての各国の判断をお示しします。争点は2つで、文言侵害の成否と均等侵害の成否です。このようにすべての国で文言侵害が不成立、均等侵害が成立という結果になりました。では、まず大高所長に文言侵害の判断のポイントをご説明いただきます。
それでは、本件明細書に基づいて、本件発明について説明いたします。本件明細書には、本件発明について次のような説明があります。従来の中空ゴルフクラブヘッドは、黄色で示した金属製外郭部材と、緑色で示した FRP 製外郭部材という2つの部材を接着剤で接合して、中空構造のヘッド本体を構成していましたが、金属製外郭部材に用いられる金属材料によっては、接着剤のみでは十分な接合強度が得られず、ゴルフクラブヘッドとしての耐久性を確保することが困難な場合があったという問題があったことから、本件発明は金属製外郭部材に用いられる金属材料に依存することなく、金属製外郭部材と FRP 製外郭部材との接合強度を高めることを可能にした中空ゴルフクラブヘッドを提供することを 目的及び課題とすることが説明されております。本件発明の特許請求の範囲の記載は、スライドに示す通り、構成要件 A から F までで構成されております。構成要件 A 記載の従来の中空ゴルフクラブヘッドの構成に、構成要件 B から E の構成を加えたというのが本件発明の特許請求の範囲です。次に本件明細書には、本件発明はスライドの上の図に示すように、黄色の金属製外郭部材の接合部に複数の貫通穴を新たに設けたこと、緑色の FRP 製外郭部材と同じ材質である熱合化樹脂であるエポキシ樹脂を含有する赤色の FRP 製糸部材を新たに設ける構成としたこと、複数の貫通穴を通された FRP 製糸部材を接着剤とともに金属製外郭部材と FRP 製外郭部材との間に介在させることにより、金属製外郭部材の接合部が FRP 製外郭部材の接合部に接着される構成としたことが、従来技術に見られない特徴的構成であることが開示されております。このことは、先ほどご覧いただきました従来技術を示す図2と、本件明細書の段落の0022に、貫通穴及び糸部材をいずれも備えていない比較例よりも、本件発明の実施例の方が接合強度が高いことの記載があることから明らかです。本件発明は、このような構成を採用したことによって、貫通穴を通された状態で、FRP 製糸部材の形状が維持され、金属製外郭部材を掛け止めすることができ、しかもエポキシ樹脂の硬化後は互いに相互に接着されるため、金属製外郭部材に用いられる金属材料を FRP 製外郭部材との接着性が良好なものを選択しなくても、接合強度を高めることができるという効果を創することに技術的意義があります。この点が本件発明の本質的部分であるものと認められます。ところで、本件発明の特許請求の範囲には、FRP 製糸部材について、構成要件 C で、前期複数の貫通穴を通されて、金属製外郭部材の内面と外面を交互に通り、その形状が維持された FRP 製糸部材と規定しています。この文言から本件発明は FRP 製糸部材が金属製外郭部材の複数の貫通穴を通り、しかも金属製外郭部材の内面及び外面を交互に通る構成であると理解できます。被告製品はスライドの図に示します通り、緑色の FRP 製外郭部材、黄色の金属製外郭部材、FRP 製糸部材に相当する赤色の帯辺を備えています。赤色の帯辺はそれぞれ一つの貫通穴に通されているだけであり、複数の貫通穴を通されての構成を備えていないので、構成要件を充足しません。したがって被告製品については、文言syn解が成立しません。
ありがとうございました。次に、均等侵害については、最高裁がスライドの5要件を示しており、このうち第1から第3要件は、権利者が主張立証責任を負うものとされています。この3つの要件の判断のポイントをお願いします。
はい。まず第1要件についてですが、本件発明は FRP 製糸部材が複数の貫通穴を通されての構成であるのに対し、被告製品は一つの貫通穴を通されての構成である点で相違します。他方で被告製品は構成要件 C のそのよの構成、構成要件 A、B、D、E および F の構成をいずれも備えているものと認められます。そうしますと被告製品は先に述べた従来技術には見られない特徴的構成を備え、本件発明の本質的部分を備えているものと認められるので、本件発明と被告製品の相違部分は本件発明の本質的部分ではないということに帰結します。従いまして被告製品は第一要件を充足します。次に第二要件についてですが、本件発明の特許請求の範囲に記載された FRP 製糸部材が複数の貫通穴を通されての構成を一つの貫通穴を通されての構成に 置き換えた場合であっても、金属製外郭部材に用いられる金属材料について、FRP 製外郭部材との接着性が良好なものを選択しなくても、接合強度を高めることができるという本件発明と同一の作用効果を相するものと認められます。従いまして、被告製品は第2要件を充足します。第3要件についてですが、本件発明がすでに公開されていた被告製品の製造時においては、本件発明における FRP 製糸部材が複数の貫通穴を通されての構成を一つの貫通穴を通されての構成とすることが、必要とされる接合強度の程度や製造方法などを勘案して、同業者が適宜選択すべき設計的事項に過ぎないものと認められます。従いまして、当事者が容易に相当することができたものと言えます。そうしますと、被告製品は第3要件を充足します。以上の通り、被告製品は均等論の第1要件から第3要件を充足しますので、本件発明の技術的範囲に属することになります。
ありがとうございます。日本の第4要件及び第5要件は、侵害者側に主張立証責任がありますが、第4要件については被告の主張がありませんでした。第5要件についての説明の前に、まずは他の国の理由付けについても伺いたいと思います。まずはドイツに伺いたいと思います。Judge Baha, according to the answer you sent in advance, you denied literal infringement as well, on the ground that the claim requires every thread to pass through plurality of the through holes. Here is a slide showing requirements of German DOE. Please elaborate your decision on DOE infringement along with an explanation of the DOE requirements.
Thank you very much. And thank you very much for giving me the opportunity to talk to you about these subjects. Now, the first thing I want to mention is it is quite astonishing that 5 different courts dealing with the same case come to the same conclusion. So I think this decision must be the right one. So what are the reasons from a German point of view that I would come to this decision? There are 3 requirements for equivalence. The first one, I think, is quite similar to the second criteria from Japan. There must be means which do not fall under the wording of the patent claim, but which have essentially the same effect. In this case, and I think this is the most important criterion in this case, and I think it's the decisive criterion, because the major effect and the essential effect, in my view, is that the bonding strength is raised by these threads, by one thread which goes through a plurality of holes. And this is because, as it is mentioned in the patent description, because it has the effect of some kind of hook. Well, meaning if you imagine a hook, it fixes the metallic portion on 2 sides to the plastic portion of the club. So this effect is not achieved as a whole, because in the embodiment in suit, well, the hook is just fixed on one side of the plastic member, but as the patent does not state any limit or any concrete value for the bonding strength, I think it's the same effect, because there is a hook which strengthens the bonding strength, and therefore I think the first criterion is met. So the second criterion is called obviousness. This means a person skilled in the art should have been possible for a person skilled in the art finding this alternative solution without an inventive step. and I think it's quite clear if you have read the patent as a person skilled in the art, it's not too difficult to find out that, well, having a hook which is fixed just on one side of the outer member has the same effect, albeit to a lower extent. The third criterion in Germany is, I think, very much the same as it is in England and Wales. We just have invented another name for it. We say the considerations the skilled person has to make to arrive at these alternative means have to be oriented to the technical teaching which is protected by the patent claim. This means we have to have another look at the patent claim and ask us once again, does the patent claim require that this effect is reached by some certain way or by certain means which perhaps are not fulfilled at the embodiment which is at suit. In our case, I couldn't find such an aspect which would rule out that this, well, imperfect hook, as I might call it, has to be ruled out or is ruled out by the claim. It may be, presumably, it may be not as effective as the solution which is protected by the wording of the claim, but it has the same effect and it is the same manner of effect, and therefore I would say it is oriented to the claim, and so also the third criterion is met. Thank you for that.
Thank you, Judge Baha. I think the third requirement is the most difficult, so I have a question regarding third requirement. This is paragraph 15 of the specification. I understood that you found that the paragraph 15 does not disclose FRP strips in defendant's product. Is my understanding correct that if the specification discloses same structure as defendant's product, the third requirement will not be fulfilled?
This is correct. There is case law in Germany stating exactly that if a specific, and I have to stress this word, if a specific embodiment is disclosed in the description, but is not claimed by the patent claim, by the wording of the patent claim, then as a rule, this embodiment may not be viewed as an equivalent. So if paragraph 15 of the description would covered the defendant's product, then as a rule, according to German case law, it would not be seen as an equivalent.
So my next question is that, is it fair to say that the third requirement may function like the U.S. dedication to the public rule in preventing patentees from recapturing unclaimed equivalents, which are disclosed in the specification?
This is correct, but I have to add one thing. This is only one aspect which can be relevant under the third criterion. So there may be other aspects which lead to the conclusion that the third criterion is not met. But this aspect is one of the relevant aspects for assessing this third criterion.
Thank you very much, Judge Baha. So next, I'd like to move to UK. In the UK, the infringement under DOE is introduced by Actavis judgment in 2017. Here's the slide showing the DOE questions shown in Actavis case. Justice Birth, could you please tell us about activist DOE questions and elaborate your decision?
Yes, thank you very much. And can I just start by saying it's a real pleasure to be here. The reputation of the Japanese system in intellectual property law in the world is unrivaled, particularly the IP High Court in Japan. And as I said, it's really good to be here. And I'm just sorry that we can't be with you in person. And I hope one day we will all manage to have a similar conversation, but in the same physical space. Judge Bakker already has observed that all these major jurisdictions have come to the same conclusion. And I think, I agree with him that I think it tells you it's the right answer, but I also think it illustrates something else, which is that intellectual property law now is very international, and actually courts and attorneys around the world are talking to each other in a way which they never used to. And this is a positive thing, because in the end, these patents are from the same families when they're litigated in different countries, and you would expect, I would say, as a generalization, details always are different, but as a generalization, you should be getting the same answers in every state. It's a good thing that the UK, Germany, Japan, the US, everywhere is coming to similar conclusions. And so this opportunity to share ideas and have a discussion, I think, is really fantastic. Now, as far as the doctrine of equivalence is concerned, just to put the Actavis decision into context, the first ever telecommunications patent case that I'm aware of, at least that took place in the United Kingdom, was in 1911, and it was Mr. Marconi, who was one of the inventors of the whole world of telecommunications. And in that patent judgment by one of my predecessors, he articulated that there was a doctrine of equivalence in the United Kingdom, essentially that obvious equivalence should be regarded as infringements. So that was our law more than a century ago. Over the intervening century, we moved away from a doctrine of equivalence so that by the late 1970s, our law had gone in a direction of what it regarded as favoring certainty, predictability, because it was felt that the doctrine of equivalence was not a predictable doctrine, because if you took the words of the claim, you couldn't be sure what would be covered, because equivalents, which were not within the wording, in some way or other, were being infringements. And so our law was against a doctrine of equivalence. There was then a legislative change at the European level, the European Patent Convention, which both Germany and the United Kingdom are members of. And if I can also just say, we're still there. The United Kingdom is still in that bit of Europe, and long may that continue. And that change put equivalence firmly into the legislative basis for our law. And it took until 2017, in the Actavis decision for our Supreme Court, to deal with it and say, yes, that meant we now do have a doctrine of equivalence. Now, what that doctrine is really, at a broad level, the same as yours in Japan, I think, and the same as the one in Germany, and the same as the one in the US. They differ in details, but it's easy to obsess about the details. Broadly, they are the same doctrines. The activist system has a three-step test. Of course, the prior question is, does it infringe on the literal wording? And of course, if it does, then there's no issue of the doctrine of equivalence. But assuming it doesn't, the first question is about, is it essentially the same effect, just as Judge Bakker put it? We put it as being, is it performing it producing substantially the same result in substantially the same way? And applying that doctrine to the facts of this case, just as Judge Bakker explained, it seems to me, trying to look at it from an English perspective, that the bonding strength is better because of those threads and because they're hooking round that member. That produces an improvement. It may not be as good as the core invention in the patent, which is slightly better by having the threads all hooked together, but it's still better than not doing it. And so it's the same, substantially the same result, and is being produced in substantially the same way. And so we would say the first question is satisfied. The second question is about obviousness. Now, it's important to understand, at least from the UK perspective, that the question is not whether the infringement is an obvious thing to do given the invention. That's not the question. The question is whether, knowing what the alleged infringement is it obviously an equivalent to the claimed invention, which is a slightly different thing. It's never been 100% clear to me whether different countries look at it in quite that way. And to be honest, I'm not sure it makes a great deal of difference, to be frank. But that is clearly where, at least in the United Kingdom, we've got to on that second question. And I can tell you, in all honesty, I've never heard of a case in which that second question failed, if from the point of view of the patentee, if the first question was satisfied. But maybe one day there will be. And that takes me to the third question, which is whether the claim language nevertheless should be understood whether the patent, I should say, the patent as a whole, should be understood as requiring strict compliance with the language of the claim. In other words, really, is this a claim in which you should be allowed to catch equivalence or not, based on the teaching of the patent? I think the way it's looked at in Germany is slightly different, but again, in practice, I think we all come to the same answer. And I would say in that respect that the third question, as we now approach it in the UK, is a hard question for the patentee to fail on if he's passed on the first and second questions. But there are examples, and you mentioned one in your question to Judge Bakker, in which you can say the patentee fails. But that's my impression of it. An outstanding question, if I may, which we have in the UK, which we have not answered yet, is whether the scope of the patent, including the doctrine of equivalence, is the scope which has to be tested for validity, or whether the validity questions are all to be tested based on the scope of the patent without applying the doctrine of equivalence. And we are not happy in the United Kingdom that we have a perfect answer to that question, because on one view, you could say, well, you should only consider the validity of the patent relative to the literal scope. But the trouble with that, we find, is it's not clear how, in our law, that is the right approach, although it is a pragmatic one. Whereas, on the other hand, if you apply a doctrine of equivalence scope, if you apply validity to a doctrine of equivalence scope, you can have claims being found to be invalid when the patentee can say, but I never claimed that in the first place. That's not fair. And I recognise that, and so there is an issue there which we are not happy we've resolved. But that's the UK approach to answer your question. Thank you.
Thank you very much, Justice Peirce, and thank you very much for your kind word for IP judicial system. And I didn't know that there used to be DOE long time ago in your country, so it was very informative presentation. Thank you. And I'd like to ask you one question. How did the Actavis judgment affect the determination of literary infringement? Do you think the conclusion of literary infringement would have been different in the world before Actavis? Could you just brief answer, please?
Yes. Well, the answer, I can tell you the answer. The simple answer is, in theory, the answer to your question is no, it should make no difference, because in theory, our doctrine of equivalence is an addition to our conventional approach to the interpretation of patent claims. However, I have to be honest with you and tell you that I think in practice, it will make a difference, because I think judges will find less pressure from their point of view of doing justice to stretch using an interpretation approach, a claim, which they think it should, because they can now take a more literal approach to infringement and still reach what they regard as the correct answer by using a doctrine of equivalence. So, to be honest, I think in practice it will make a difference, but in theory it should not.
Thank you very much. I will now move on to the US. Here's a slide of the DOE requirements of the United States. Mr. Michael John, could you please explain your decision along with the explanation of the DOE requirements and the bars or defenses?
Sure, I'd be happy to. Thank you very much, Judge, and good evening, everyone. It's a real pleasure for me to be here. It would be a little bit more of a pleasure if this started about 6 hours earlier or 6 hours later, but still it's a pleasure. So in the United States, the doctrine of equivalence has 3 different tests, and you have to satisfy one of those tests. You don't have to satisfy all of them, just one of them. The first test is the function, way, and result test. That means you have to determine whether a component in an accused product performs substantially the same function in substantially the same way to give substantially the same result. That test is the one that is used most commonly. By far, it's the test that's used most of the time. It's used typically in what we call predictable technologies that involve mechanical inventions or electrical inventions. The second test is the insubstantial differences test. And basically that means is the component in the accused product insubstantially different from the component in the patented product. And if it is, then there's doctrine of equivalence, and if not, there's not. This test is used in chemical areas and in pharmaceutical cases and in biotechnology cases. And the final test, known interchangeability, that is the component in the accused product interchangeable with a component in the patented product, and did one skilled in the art know that at the time the application was filed? So anyway, there's these three tests. If any one of them applies, you've got what we call equivalence in fact. It's not, that doesn't mean the doctrine of equivalence applies. It just means there is equivalence in fact. There's a second step where you have to determine whether any bars to the doctrine of equivalence apply. Now, I use the function way result test with respect to this particular problem. The way and result are substantially the same as explained by my friend from the UK, and the function is clearly substantially the same between the accused product and the patented product. So once you determine that there is equivalence in fact through this function way result test, let's say, you then go to the next slide and see whether any of the bars to applying the doctrine of equivalence apply. The first is prior art defense. That is, if the alleged equivalent is an obvious variant of a component of a product that's in the prior art. You can't use the doctrine of equivalence to sort of claim the prior art. Second is dedication to the public. We've talked about that already a little bit. Dedication to the public means that if you've got some disclosure in your specification and you don't claim it, then you've dedicated that subject matter to the public, and you can't use the doctrine of equivalence to recapture that dedicated subject matter. So for example, let's say you're talking about a coupler to couple some things together, and there's maybe 5 different kinds of couplers, A, B, C, D, and E, but you claim only 4 of them, A, B, C, and D. Well, E is dedicated to the public, and you can't reclaim E using the doctrine of equivalence. I'm going to skip the claim vitiation doctrine. Claim vitiation means that you can't use the doctrine of equivalence if, by doing so, you would vitiate or render meaningless. That's what vitiate means, render meaningless a claim element. Stated differently, you can't use the doctrine of equivalence to capture the antithesis or the opposite of what you're claiming. It's kind of a hard concept to understand. So I think it's best understood by using an example. There's a bunch of cases in the United States where claim vitiation is used to bar application of the doctrine of equivalence. For example, in one case, one of the components was described by the patentee in the claim as being non-metallic. It was a non-metallic component. The accused product had the same component, but it was metallic. So the claim said non-metallic, the accused product was metallic, and the patentee tried to extend the claim, broaden the claim to include metallic component. Court says you can't do that. You can't use the doctrine of equivalence to claim something which is the antithesis or the opposite of what you claim, because if you did so, the claim limitation would have no meaning. If the claim limitation reads on things that are non-metallic as well as metallic, then it reads on everything and is really not a limitation. There's a whole bunch of cases like that in the United States where you have opposites, majority, minority, above, below, that kind of thing. So the last bar to using the doctrine of equivalence is prosecution history estoppel. This is the most frequently used bar to application of the doctrine of equivalence. And it's a two-step process. First, there's a presumption drawn that there is prosecution history estoppel if there's a narrowing claim, that is, the claim is narrowed during prosecution, or there's an argument made during prosecution that would narrow the claim. Now, that presumption can be rebutted, and it can be rebutted in one of three ways. Number one, if the alleged equivalent was unforeseeable, that is, the patentee couldn't foresee that a particular equivalent was equivalent at the time of filing the patent application. Secondly, if the alleged equivalent was, if the amendment that was made is only tangential to the alleged equivalent. For example, if the amendment was narrowed, didn't exclude the equivalent. It excluded some other subject material, but not the equivalent. And third, any other evidence, any other objective evidence that the patentee can come up with that shows that the patentee did not mean to exclude the particular equivalent. So in summary, I use the prosecution history estoppel. That was the only one that kind of applied here. The amendment was narrowing, and on the other hand, the presumption was rebutted by the fact that the amendment that was made was simply tangential to the equivalent. Thank you.
Thank you very much, Mr. Michael John. Your explanation was very clear with a lot of examples, so I understood well. Thank you. And I would like to move on to Japan now. それでは各国の均等論の成否について伺ってまいりましたが、明細書の記載や出願経過が問題となるようです。日本の模擬裁判で被告は被告製品が特許出願手続きにおいて特許請求の範囲から意識的に除外されたものにあたるなどの製品と特許請求の範囲に記載の構成とが均等なものとは言えない特段の事情があるから、均等論の第5要件を満たさないと主張しています。そして第5要件に関する一つ目の主張として、被告は原告が本件補正により複数の貫通穴を通される対応のうち、金属製外郭部材の内面と外面を交互に通る構成に限定したことが意識的除外にあたると主張しています。この点について大高所長、どのように考えるか教えていただけますでしょうか。
はい、本件補正は、本件補正前の前期複数の貫通穴を通され、その形状が維持された FRP 製糸部材という発明特定事項では、FRP 製糸部材が複数の貫通穴をどのように通る構成であるのか明瞭ではないという趣旨の挙動理由通知を受けまして、明瞭でない記載の釈明を目的とし、この発明特定事項を前期複数の貫通穴を通されて、前期金属製外郭部材の内面と外面を交互に通り、その形状が維持された FRP 製糸部材と補正したものです。このように本件補正は明瞭でない記載の釈明を目的するものであり、特許請求の範囲の厳縮を目的するものではなく、また本件発明の発明特定事項から特定の構成を除外することを意識したものと認められないので、被告の主張は採用することができません。
さらに、本件では被告は第5要件に関し、本件明細書の15段落の記載は、複数本の糸部材を配して接着する構成を認識しながら、あえて 前期複数の貫通穴を通されて前期金属製外郭部材の内面と外面を交互に通る構成に限定することを表示したものである旨主張しています。この主張についてはいかがでしょうか。
はい。本件明細書を見ますと、本件発明の実施形態について、0011から0014の段落で、スライドの上の図2に基づいて、赤色の1本の糸部材が複数の貫通穴に通されることを説明し、これに引き続き、0015の段落の記載があります。先ほど示しました0015の記載中の金属製外郭部材11に複数本の糸部材22を配して接着させても良いとの部分は、それまでの説明と同様に糸部材22が複数の貫通穴に通されることを前提とした上で、例えば糸部材の本数を1本ではなく2本としても良いことを述べたものと見るのが自然です。そうしますと、0015の記載は、被告製品の構成である FRP 製糸部材が一つの貫通穴を通されての構成を前提とした上で、複数本の糸部材を配して接着させても良いことを開示したものということはできないので、被告の主張は採用することができません。
ありがとうございました。それでは、均等論の論点の一つについて各国に伺いたいと思います。I think there is an argument that the application of DOE should be limited to cases regarding after arising technology. I would like all judges to answer this question briefly, please. First, Mr. Michael John, what is your opinion to this argument?
Well, that argument's been resolved in the United States through the Eli Lilly against Hospira case. In that case, the patentee argued that the doctrine of equivalence should apply only to after arising technology and not to technology that existed at the time the application was filed, because the patent applicant had the opportunity to literally encompass all such equivalence and didn't do so. Federal Circuit said no. It's not really practical to expect somebody to write a claim that would encompass all possible known equivalence at the time. So the doctrine of equivalence is not limited to after arising technology. It includes also technology that's known at the time of filing of the patent application. There were actually that case also was petitioned for certiorari to the Supreme Court of the United States, but the Supreme Court hasn't ruled on that.
Thank you.
The rule right now is that doctrine of equivalence applies to both after arising technology as well as technology known at the time of filing.
Thank you. Next, Justice Burrs. Same question to you.
Thanks. Yes, that's a hard question to answer. We don't have a simple decision in the way that they have in the United States that addresses this question. And my opinion is that it's difficult. I would expect that if this question comes up to be answered in the UK, the answer will be that similar to the US, in the sense that it won't be an absolute bar to be able to use the doctrine of equivalence to catch technology which was already known at the time, obviously added to the invention. I think it's unlikely that we would end up with a legal principle as sharp or as hard as that. On the other hand, I do see that when the third question is being approached, at least in the English courts, very often one of the arguments that's advanced is to say, well, if the equivalent feature is something which the skilled person already was well aware of as part of their common general knowledge, and then if that was true, then when they read the patent, they might say, well, the patentee clearly must have decided not to claim that because they must have known it as well. And so I should not be using the doctrine of equivalence to stretch the claim to catch something, not just something which is a disclosed embodiment. Disclosed is not claimed, and not claimed, which you've already been discussing before, but also things which were very obviously potential equivalents. So I don't know. I think it's a tricky issue, to be perfectly honest with you.
Thank you very much. So, how about your opinion, Judge Baha?
Well, we don't have a decision on this question either in Germany. But on the other hand, this question has never been raised so far. And I think the reason for that is that there is no such limit. And I think we apply the doctrine of equivalence to each type of patent. But on the other hand, I think what Colin Burst just said would also apply to Germany. If it is a well-established field of technology, then the defendant may be inclined to say, well, if the patentee wanted to have protected this solution, then he would have mentioned it in the claim. So if he didn't mention it in the claim, this may be an indicator that it is not equivalent. But this is not a question of law, but just a question of fact in the case which has to be decided.
Thank you very much. それでは、次は代理人の視点からの議論をしていただきたいと思います。城山弁護士、よろしくお願いいたします。
はい、模擬裁判で、原告代理人役を務めました、城山でございます。模擬裁判のビデオをご覧にいただいた方はお分かりかと思うんですけれど、最初3分の1ぐらいの時間使って、そこそこそれなりに力を入れて、文言侵害の主張を、原告代理人としております。で、今回のこのシンポジウムの、お題は、均等論だというのは、最初から指示されておりましたので、おそらく文言侵害は、認められないんだろうという、そういう設定の、説例だということは理解しておりましたが、やはり原告代理人としてはまずは文言侵害主張するだろうということで、主張をさせていただいた次第です。で、4カ国のうち1カ国ぐらい、文言侵害認めてくれるかなと、少しは期待はあったんですが、見事に4カ国とも文言侵害は否定されました。で、相良先生、まず、ちょっとご意見を伺いたいんですけど、原告代理人の立場だったとしたら、文言侵害、ちょっと難しいかなと思っても文言侵害主張するかどうか、この点の、感覚いかがでしょうか。
はい、私が、原告代理人であったとしても、やはり同じように文言侵害をまずは、論ずることになるだろうと、たとえこの事案であっても、文言侵害を主張しただろうというふうに思います。やはり均等論を最初から主張するというのは原告代理人にとってはとても勇気のいることで、後がなくなるという感覚がありますので、少なくとも訴状の段階では均等論に触れたくない、諦めがついてから均等論に行きたいというふうに、通常考えております。ただ、この事案に関しては、各国とも文言侵害が否定されている結果を見ても、明らかですけれども、やはり文言侵害が認められるというのはなかなか厳しいなというのは最初から分かっていると、思いますので、提訴する段階から、もう均等論を主張することになるということを、想定して、ある程度早い段階で均等論を主張することになるだろうなというふうに思います。
ありがとうございます。続いて、大高所長に、質問させていただきます。マイケル・ジョン弁護士のプレゼンテーションで、アメリカでも、Prosecution History Estoppel というのは、most frequently に、例示されるディフェンスだという話ありましたが、本件でも、日本でも第五要件として問題になります。ただ、日本では特にクレームの文言侵害においても、出願経過を参酌するというのは非常によく行われているものと理解しております。で、文言侵害におけるこの出願経過の参酌というものと、この均等の第五要件としての意識的除外に当たるかどうかと いう観点からの出願経過の参酌で、具体的に何か違いは出てくるのでしょうか。
はい、クレームの文言解釈の際に出願経過を参酌すべきかどうか、参酌するかどうかが問題となる場合というのは、出願経過はクレームを限定解釈する根拠となるかどうかという観点から検討することになります。これに対して均等の第5要件においては、被告製品の構成がクレームの文言を充足しないと、いわばクレームの外にあることが前提となりますので、出願経過はクレームの外にある被告製品の構成を意識的に除外したことを客観的、実質的に見て表示したものと認められるかどうかという観点から検討することになりますので、出願経過を検討する観点に違いがあるかと思います。
ありがとうございます。では、続いて、ドイツ、イギリスの判事にまず質問したいと思います。I have a question to Judge Baha. I understand from I understand from U.S. presentation that in U.S. Prosecution history, Estoppel is a frequently raised defense against the argument based on doctrine of equivalence. But I think you didn't clearly or specifically refer to prosecution history when considering the applicability of doctrine of equivalence. In your country, the prosecution history is considered when you determine the applicability of DOE?
Well, I think there is a reason why I didn't mention this aspect so far, because as a rule, prosecution history is not relevant according to German doctrine. Recently there have been some decisions where the Federal Court of Justice considered whether or not under certain circumstances, the prosecution history might be relevant, but it is quite clear, if ever, these will always be exceptional cases. So the standard or the test is, can the history or the declarations given by the patentee be viewed as a waiver? Did he waive certain rights? Did he give something to the public which he is not allowed to take back? But there is no presumption. I would even say there is a presumption that he did not want to make such a declaration. So there have to be very exceptional circumstances for a German court to come to the conclusion that prosecution history does rule out equivalence.
Thank you very much for the clear explanation. Next, Judge Burst, how about UK?
Thank you. Well, the answer, the short answer is the UK and Germany are doing exactly the same thing on this question. One extra piece of explanation is that one of the reasons why we abandoned the doctrine of equivalence was because of prosecution history, Estoppel, because it was felt that it was difficult to have a doctrine of equivalence without opening the door to having too much reliance on the prosecution history, which we hate because we think it's not useful, but is very involved. It creates involved arguments which ultimately lead nowhere. And that was definitely one of the reasons why our courts did not favor the doctrine of equivalence. So I can tell you that we are trying very hard to keep the lid down on the prosecution history arguments because we don't think they're very helpful except in exceptional cases. Thank you.
Thank you very much. Mr. Michael John, yeah, I understand that you in United States, prosecution history Estoppel is frequently raised defense against the arguments under DOE. How about the claim construction for the purpose of literal infringement? For the purpose of determination of literal infringement, is prosecution history also considered as a base for claim construction?
Yes, it is. The prosecution history is part of what we call the intrinsic evidence. The intrinsic evidence is the patent specification, the patent claims, and the prosecution history. All three of them can be used to construe a claim. The prosecution history can actually be used to construe a claim more broadly than it's written, depending upon what's in that prosecution history. And of course, the prosecution history can be used to, with respect to the doctrine of equivalence, to preclude the doctrine of equivalence if an amendment is made which is narrowing, or if an argument is made that effectively narrows the claim. Yeah, so it can be used for both literal infringement and for doctrine of equivalence.
Thank you very much.
城山弁護士、ありがとうございました。ここまで各国の均等論と模擬事例についての判断のポイントについて伺ってまいりましたが、要件や検討手法は異なるものの、被告製品が達成する効果や結果に着目する点、明細書の開示により被告製品が発明の保護範囲から除外されていないかを検討する点、出願経過が均等侵害の製品に影響し得るとされる点など、共通する点が多くあることが分かりました。さらに議論を深めたいところではありますが、時間の関係もありますので、後半に移りたいと思います。後半のテーマは、新型コロナウイルス感染症の影響下での裁判運営です。前半の実態法の議論とは趣を変えて、各国の現状について議論したいと思います。まず、新型コロナウイルスが裁判実務に与えた影響の概要についてプレゼンテーションをしていただき、その後、質疑応答を行います。最初に、熊谷裁判官、日本の状況について説明してください。
それでは私の方から説明します。このグラフにもありますように、日本でも昨年の春以降、新型コロナウイルス感染症が拡大し、2020年4月7日に政府によって最初の緊急事態宣言が発令されました。裁判所全体として日本政府、各地域の自治体から人と人との接触機会を7、8割程度低減する旨の要請があったことなどを踏まえ、最初の緊急事態宣言発令中、感染拡大防止策として、業務を特に緊急性の高い事件のみに限定するなどの対応を取りました。知財高裁でも緊急事態宣言が発令された2020年4月7日から裁判官の申し合わせにより保全事件などの緊急性の高い事件を除いては事件の進行を停止する措置を講じました。その後5月25日に緊急事態宣言が解除されたことを受け、6月1日からできる限り電話会議、ウェブ会議等を利用して当事者を裁判所に出頭させることなく期日を進めるなどの措置を講じてきました。第1回の緊急事態宣言解除後、このグラフにありますようにコロナウイルスの第2波や第3波が起き、再び緊急事態宣言が近時発令されるに至りましたが、今のところウェブ会議をはじめとする各種の措置を適切に講じることで、感染防止と司法機能の維持という2つの要請にうまく応えることができていると思います。ここでコロナ禍で重要な役割を果たすようになったウェブ会議について少しだけ説明をしたいと思います。日本の民事裁判実務では、裁判所が争点や証拠の整理に関して指導的な役割を果たし、時に裁判所が争点処理手続きにおいて積極的に和解の監視まで行うというところに特色があります。コロナ禍の前から日本では民事訴訟手続きの IT 化を始めており、その第一段階、フェーズ1として争点処理手続きをウェブで行うということを順次始めており、知財高裁でも2020年2月から全国のトップを切ってその運用を開始していました。ここにありますように、ウェブ会議では マイクロソフトの Teams を全国の裁判所で統一的に利用しています。なお、この写真では、出演者はマスクをしていませんが、現在は現下の情勢から裁判所側は全員マスクをして手続きをしています。弁護士、弁理士をはじめとする司法関係者のご理解ご協力もありまして、ここにありますように、裁判所全体でウェブ会議の実施件数は近時急激に増加しています。現在、自在高裁では、ほとんどの争点整理手続きがウェブ会議の方法により行われています。個人的な印象としては、自在訴訟では、一般的な民事訴訟よりも、ウェブ会議が実施される率が高く、争点整理手続きの8から9割程度でウェブ会議が利用されています。このように、日本の裁判所においては、ウェブ会議がコロナ禍における司法機能の維持に重要な役割を果たしていると言えます。私からは以上です。
ありがとうございました。Next, I'd like to ask Justice First to make a presentation on overall effects of COVID-19 pandemic on the court's practice.
Thank you very much. I hope can you see that?
Not yet. Yes.
How about?
Yes.
Thank you. So this is to explain the experience we've had in the Patents Court in London as a result of the COVID pandemic. Why? No. Here we go. Right. So before March 2020, almost all the hearings in our court were face-to-face hearings. In other words, the participants physically in court. We did do a few hearings by telephone for case management. We did also have quite a lot of partial video conferencing for large international trials. So a patent trial with witnesses from America or Japan or whatever, they would appear by video conference. That was common, but that would be only a single screen with a single individual, a witness usually, whereas all the other participants were in the physical space. After the beginning of the first UK lockdown, and you know our experience of COVID has been pretty bad. We've all had a terrible time around the world, but the Brits seem to be making a real mess of it. But there it is. It meant that social distancing made it impossible, or very difficult at any rate, for many face-to-face court hearings. But access to justice was very important, and so we moved to video conferencing in a week from a standing start. And we just used Skype for Business, which is an old technology, but it worked. And we operated a triage system to work out what was the appropriate mode for every hearing. So we now today, and really for the rest of 2020 and still going on now, have three kinds of hearing. We still have face-to-face hearings. They're very rare, but sometimes there is a good reason, so we still do that. And there the court practices social distancing. There are very few humans in the court. And most people are wearing PPE, personal protection equipment of one sort, masks and the like. And then we also have fully remote hearings by video conferencing. This is by far the majority of all the hearings that we've done in the whole of 2020. It includes some full trials and all case management. And we also now have what we call hybrid hearings, which are partially video conference and partially face-to-face. These are quite popular, but they can be technically difficult. In terms of practicalities, absolutely vital is the ability to file documents electronically, which we've had in our patents court since 2015. Other parts of the English court system in our local courts don't have that, and that's been very difficult. But in the patents court, we have had electronic filing, and that was absolutely vital. It also has forced judges to use electronic documents directly more often than they ever used to. Although we had electronic filing, often what was then filed was printed out, whereas now everyone is getting used to using documents on the screen, which is a great advantage. The video technology we use, I mentioned Skype for Business. We've learned, as we all have around the world, that you have to run tests in advance. We've learned to tolerate problems, but we seem to have managed it. One problem is when you have multi-cameral courts, in other words, a court with more than one judge, like an appeal court in our system, and that can be difficult because the judges have to learn to communicate with each other remotely at the same time, but also in a private way. The results are, I think, positive from our point of view. The Patents Court has no backlog at all. We did not adjourn anything except some rare cases where there was a real problem. But the number of adjournments was very, very small. We kept our trial timetable, our trial calendar, all the way through 2020. And what we've learned is that we will be using video conferencing in future when social distancing to deal with the pandemic is not necessary. But we need to learn how best to use it. And one concern is that some people in society don't have the facility to use technology in a good way, and we need to recognize that and not shut people out. But the most important lesson, which I'd like to share with you all, is that what we've learned in our court over the last year is that we can change the way we do our work. And that has been something which many, many judges and lawyers did not believe, but we can. Thank you.
Thank you very much. Next, Judge Baha, please start your presentation.
Thank you very much. As a Supreme Court, the Federal Court of Justice is in a different situation, but nevertheless, the patent division has been affected quite in the same way. So, talking about figures, we have some courtrooms which have some kind of standard size. Normally, up to 30 persons may participate in a hearing. Now, only 9 persons plus the judges are allowed. Our largest courtroom is well dedicated for very important cases. It's normally 90 persons may have access to it. At the moment, 30 persons is the absolute maximum. Of course, we do have travel restrictions. It's quite, if not impossible, quite difficult for foreign parties to enter Germany. And so this would have meant for us, we would have had to adjourn almost every hearing for some reasons. This does not apply to other divisions of the Federal Court of Justice because it's the Supreme Court. It's only decides normally on questions of law. There are only 40 lawyers who are admitted to this court, all of them located in the city where the court is located too, so they don't have to travel. So most of the Federal Court of Justice does not have too many problems with COVID-19 so far. Things are different in patent cases because it's absolutely usual that many lawyers plus in-house counsels plus executive, sometimes plus interpreters want to participate in the hearing. We have usually one hearing per week. And in patent validity cases, unless as in patent infringement cases, the Federal Court of Justice is also allowed to hear witnesses and experts because we have to decide on the facts as well. This meant for us in March 2020, if we had proceeded like we did before, we couldn't have made just one hearing. We would have created a backlog for many, many years. So we didn't have any technical equipment for video conferencing because, well, we didn't need it before. Things went quite well. And so we had the task of introducing video conferencing equipment very, very quickly. And we managed to do so. So there were about 4 or 5 weeks of adjournment. But from then on, we just moved on with our agenda. And we normally, and I think in 98% of all the hearings, we do it by hybrid hearings. This means all the 5 judges who are up to decide a case are in the courtroom, and 1 or 2 lawyers or advocates per party are in the courtroom too. Well, to be honest, we as judges could do without them, but most of the counsel do insist that at least one or two per party are present in the courtroom. But all the other participants, and this may be 10 or 20 or 30 people, attend the hearing via video conference. We have two types of technical equipment. In the normal sized courtrooms, we have 2 cameras and 4 screens so that everyone will be recorded and everyone is able to see each other person participating in the hearing. And we have even 4 cameras in the large courtroom, 1 in every direction and 2 very, very big screens in order to have the same result in this large courtroom. We use Microsoft Teams. We didn't have anything before, so it was easy for us to choose a quite up-to-date software. We decided in favor of Teams and not in favor of Zoom because, well, the reputation of Zoom with regards to data protection is a little bit, inferior to the reputation of Teams. And so it was easier for us to involve Teams than it would have been to introduce Zoom. Just to give you an impression of how the organization works, we send information leaflets to all the parties if a hearing is imminent. The parties tell us who wants to participate on site and who wants to participate online. All those people who want to participate online get an invitation link. We ask them to join us for a rehearsal.
Sorry for interrupting, Judge Baha. Please wrap up in a short minute, please.
Yes, I will. I will have finished in 1 minute. We have a rehearsal session 1 day before the hearing, which is very, very appreciated by the parties. And all the participants are asked to log in 15 minutes before the start of the hearing. I have 20 seconds left, so I will skip this and give you just one short impression of the courtroom. This is the smaller one. You can see all the German patent judges of the Federal Court of Justice on this video. And this is our larger courtroom. You can see here 4 cameras. You can see the big screens here. You can see the view of the audience, and you can see the view of one of the attorneys participating on site. Thank you very much.
Thank you very much. Next, Mr. Michael John, please.
Okay, you see it?
Yes.
Okay, thank you. So talking about the effect of the pandemic on procedures in U.S. courts. One aspect of litigation that's unique, I think, to the United States is that we have jury trials. And jury trials are kind of a difficult thing to carry out during the pandemic. Although in the beginning of the pandemic, some courts were still carrying out jury trials. So the first 3 slides I have are related to jury trials. This first slide just tells you about the difference between criminal cases and civil cases. So in the United States, you have a constitutional right to a speedy trial for criminals in criminal cases. That means they have to move along during a pandemic, just like the way they did before the pandemic. But there's no such right to a speedy trial in a civil case. So if you look at this little chart here at the bottom, the mustard colored is the criminal cases. And between September of 2019 and September of 2020, they're virtually the same, a 1.2% increase in the number of pending criminal cases. So basically, the criminal cases are being disposed of. But with respect to civil cases, between September of 2019 and 2020, there was a 55% increase in the number of civil cases that were pending. They're still pending because we can't do trials because of the pandemic. So this next slide shows that you have a right to a jury in both criminal and civil cases, but there's a public health risk impaneling an in-court jury. They do it in criminal cases because they have to, and they have a whole bunch of extreme regulations with respect to it. But for civil cases, they can just say, let's wait till the pandemic's over, then we'll have trials. Now, they didn't always do that. For example, in November, there was a civil case in the Eastern District of Texas. You'll see that in a lot of these slides, they're from the Eastern District of Texas. The folks in Texas think they're pretty tough and they can work through the pandemic as if there was no such thing as a pandemic. But anyway, in November, there was a civil case. It was initially postponed when a juror tested positive for COVID-19. And then the judge had to declare a mistrial when 15 people who were involved in that trial tested positive for COVID-19. So in-court jury trials now are virtually non-existent in civil cases and particularly patent cases. And remote jury trials are really rare. It's really hard to have a jury trial remote because you have to be able to have control of the jurors. And if the jurors are in their house and they're worried about their kids and they're being distracted and that kind of thing, it just won't work for a jury trial to be remote. So this slide indicates that court proceedings, that is for hearings, not trials, but hearings like motions for summary judgment or motions to dismiss, discovery motions, motions in limine, those kinds of things. The regulations of how these hearings are held, there's no uniform aspect to it in the United States. We have circuit courts, 13 circuit courts, and they can put in whatever procedures they want. One court's different from another, et cetera. We have over 100 district courts, and that they're all different one from another. And within a court, their individual judges usually have some discretion to decide how to conduct proceedings. So let's talk about remote court proceedings. These are used on everything except for trial. Civil trials, we just don't do them anymore now. So the court has the discretion to have a virtual conference platform, could be either Microsoft Teams as in Germany, or Zoom, or it could be WebEx. And these proceedings are typically fully remote. That is, nobody is in court. Sometimes the judges are, but not always. Everybody is in their house or maybe a law office or something like that. In court proceedings, if you're going to have them for a hearing before trial, you need social distancing, you need masks. They're usually required. In Texas, sometimes they're not, but most courts require masks and social distancing. Sometimes if a person doesn't want to participate in court, they can ask the judge, and if what they're going to be saying at the hearing doesn't involve visual aids of any kind, the judge will typically let them participate by telephone. The next three slides relate to three different courts.
Sorry to interrupt. You're running out of time. So
three different courts. One is the Federal Circuit. Federal Circuit's not much different than it was before. They used to have oral arguments in person. Now they're telephonic. There's no video. Then there's two district courts. They're both in Texas, Eastern District, Western District of Texas. They are courts where they try to have trials during COVID, but eventually, like now, there's no more trials because of the outbreak being so strong, both in the Eastern and the Western District of Texas. In terms of the future, people tend to like the remote hearings. Judge Lynn, for example, of the Northern District of Texas, she likes these remote hearings. There's a lot of advantages to it. Other judges don't, like Chief Judge Gilstrap in the Eastern District of Texas doesn't like it. So we think that there's going to be a continued use of remote hearings in some fashion, not for trials, of course. The trials have to be in person.
Okay, thank you. Are you finished?
Yes.
それでは各国とも手続きの相違や程度の差といったものはありますが、それぞれリモート手続きを続けていることが分かりました。 それでは、ユーザーの立場である城山弁護士と相良弁護士からご意見をいただきたいと思います。
はい。日本では、コロナが始まる前の2019年の、後半ぐらいから、この先ほど熊谷裁判官が説明されたフェーズ1の準備が始まってたんですね。で、我々弁護士、最初はですね、いやいや、裁判所は行きますよと。私はもう好き好んで行きます。それが仕事なんだからと、思ってましたけれども、実際、コロナということも生じ、かつ、リモートで手続きが進められることになって、実際それを経験すると、非常に便利であるというのを実感しています。熊谷裁判官、ご説明された通り、フェーズ1は順調に、進行していると理解しています。私、今日の午後も大阪地裁の、準備手続きの、書面審のウェブ記述あったんですけれども、それで済んで非常に、ラッキーだなと。これもし、従来通り、新幹線で3時間大阪にかけて行って、5分間でですね、書面を陳述しますと。で、次回期日をいつにしますかというスケジュール調整だけして帰ってくるということを考えると、今からそういうことを昔やってた、ついこの間までやってたっていうことを考えると、非常にゾッとするという感覚は、あります。で、この先なんですけれども、ユーザーの立場から言うと、やはりこのままさらに進めていただきたいと。フェーズ2、フェーズ3と進めていただいて、ぜひ書面のオンライン提出というところも、しっかり、予算を取って、日本の国としてやっていただきたいというふうに考えております。それから、今のですね、手続きに関して言うと、スケジューリングの関係で、裁判官とか書記官がですね、今、やはり、裁判所の庁舎から皆さん、参加されることになっていて、それで、多少やっぱりスケジューリングのですね、難易度が上がっているという印象は、代理人の立場からはありますので、裁判官や書記官とか専門員なども、リモートで参加できるような手続きになると、さらに便利になるんじゃないかなというふうに思っております。
じゃあ私から簡単にですけれども、以前よく行われていた一方当事者が電話、一方当事者は出頭という期日ですと、やはり向こうで何が行われているんだろうという不安、抵抗感があったわけですけれども、現在行われているそのウェブ手続きは双方ウェブで参加するということで、そういった不安、抵抗感は少なかったという印象があります。また、今回の緊急事態宣言では、取り消される期日というのは本当に、ほとんどなくて、そういう意味で、多くの代理人が、このウェブ期日の、利点を体感できているんじゃないかと思います。
ありがとうございました。それでは、インターネットを利用した審理のメリットやデメリットについて伺っていきたいと思います。まず、日本について、日本のメリット、熊谷裁判官、お願いします。
はい。それではまた熊谷の方から説明させていただきます。これは先ほど示したウェブ会議の写真ですが、ウェブ会議のメリットとしては、まず移動する時間や労力が節約できますので、遠隔地に居住する当事者や代理人が手続きに参加しやすくなって、期日も指定しやすくなり、迅速かつ柔軟に審理を進められるということが挙げられると思います。また、知財高裁では、第三者の専門家が参加して、技術的な事項や争点について、プレゼンテーションや議論が行われる、技術説明会という手続きも行われていますが、現在この技術説明会をウェブで会議で行うという取り組みもされているところです。また、日本の知財訴訟では、この書面にありますようにですね、当事者双方が時に100ページ以上にも及ぶ長い準備書面を互いに提出し、争点や証拠の関係といったものが非常に複雑化することがあります。そのような場合に、口頭での議論を補うものとして、各種のツールを用いる試みもされています。具体的には、ウェブ会議では、ここにありますように、Teams の画面共有機能を使って、裁判官が争点と証拠の整理のために作ったメモを当事者と共有し、当事者と裁判所の間で事案に対する理解を 共通にするということがあります。その他にも、画面共有機能を使って和解条項案について検討をしたり、自由な争点についてチャット機能を使って議論するなどして、より実質的な争点と証拠の整理、迅速な審理といったものを実現できるように日々努力しています。私からは以上です。
では、大高所長、日本の民事裁判におけるインターネットの利用の今後の課題についてはいかがでしょうか。
はい。先ほども紹介がありました通り、争点整理手続きでは、ウェブ会議を利用していますが、現行法上、口頭弁論期日には、当事者が現実に出頭することが求められていますから、口頭弁論においては、ウェブ会議の方法で行うことが認められていません。また、証人尋問については、証人が現実に裁判所に出廷して、証言を行うことが原則とされており、映像、音声の送受信による通話の方法により実施できる場合は限られています。このような課題を克服するため、現在、法務省の法制審議会において、ウェブ会議を含む映像、音声の送受信による通話の方法で、口頭弁論の実施を可能とすることや、証人尋問を行い得る場合を拡充する民事訴訟法の改正が検討されていまして、その動向を注視していきたいと思います。以上です。
ありがとうございました。引き続き各国のパネリストからも伺いたいと思います。Judge Baha, your presentation highlights that in Germany, hybrid hearing is widely used. This is also the same as what we have researched. Please tell us pros and cons of online technology in 2 minutes, please.
I think I can be brief because the most important aspects have also already been mentioned. So it is a means of doing business under COVID restrictions. It is a means to save a lot of time for people who want to participate in the hearing, but who not necessarily have to come to the court physically. And we also use sharing parts of the patent description or figures from the patent to explain or to help explain the arguments of the parties. There is one aspect which I want to add. Sometimes parties have their own interpreters, and it is much easier to have the interpreters somewhere else than sitting in the courtroom. And I think this will also be a type of some piece of technology we will use even when we all have got vaccination someday. I will leave it to that. Thank you.
Thank you very much. Same question to Mr. Michael John, but from the perspective of a litigator, please.
The technology we now use to have remote conferences are very, very efficient. They're inexpensive. There's no limitation on who can come. If we have a deposition that might be, 3,000 miles away, it's possible in the United States. It's expensive to send one person there, but with this web technology, we could have 10 people from our firm attend if we wanted. There's basically no expense. The disadvantage is, of course, that not everybody has the same equipment. Their equipment is not as good as it should be, so that the video and audio are not really are not really appropriate. Also, they need to practice. They need to learn how to use the technology so that a deposition, for example, will go well, and that kind of thing. So that's kind of the pros and cons. I think that folks pretty much like the remote hearings, though, in the United States now. And there's some judges who are sort of old-fashioned, and they're not going to change no matter what. Everything's going to be in court. But there's a good number of judges where they're going to try to use this remote technology, I think, to have remote hearings. Thank you.
Thank you. Next to Justice Burse, you gave us strong message that we can change the way if we try. So, same question to you.
Thank you. Well, I mean, the pros and cons, I think, are the same as you've heard from our colleagues in Japan and in Germany and the US. I don't think I can really add to that. The one thing I would say that I found difficult is that as a judge, one of the skills of a judge is to preside over the hearing, which is about maintaining your authority as a judge, making sure everyone understands that you are the judge or the leader judge in a panel of judges. And as you gain experience as a judge, you find that you use all sorts of body language to control the court, as well as just speaking. I can turn my head and look at a barrister. I lift my eyebrows. And they get the impression that I'm very surprised by what they've said, and you can keep a very good control without, being confrontational, and that's much harder in the video world. And I think remote hearings, the video is absolutely fantastic, and we will definitely use it all in future, I'm sure. But you have to learn a different way of controlling the hearing, and it does require something which I think is difficult to do, because you have to be more overt. You have to put yourself forward a little bit more than you would in a physical courtroom. And it involves, and I found it hard to learn. Sometimes you have to interrupt speakers, and interruptions is always a difficult thing in any human interaction, and especially in a court, because you want the speaker, you want the public to feel that the speaker has had a chance to speak. So judges interrupting is not straightforward, but you have to do it sometimes, and that's a critical thing. But I think it's absolutely all something we can do, no question. Thank you.
Thank you very much, Justice Burse. まだまだ議論は尽きないところではありますが、時間になりましたので、このあたりで終了としたいと思います。最後に大高所長にコメントをいただきたいと思います。
はい、I would like to make some comments. First of all, I'd like to express my deepest appreciation for the participation of leading IP practitioners from the United Kingdom, Germany, and the United States. As IP disputes have become internationalized with growing globalization of business activities, the importance of mutual understanding of our respective IP dispute resolution systems is increasing. Furthermore, in the midst of this difficult situation, and under the spread of COVID-19, it is important that we share the information of the measures we take to deal with this situation. I am convinced that through the program, we have deepened such mutual understanding and provided beneficial information for not only practitioners, IP practitioners, but also practitioners in the other fields. ここからは日本語でご挨拶をさせていただきます。知財高裁のプログラムをご視聴いただきました皆様、長い時間お付き合いいただきまして誠にありがとうございました。従来の JSIP では知財高裁の担当日に各国の実務家をお招きし、知的財産権侵害訴訟の模擬裁判について各国の模擬裁判を行っていただき、これに基づいてパネルディスカッションを行うというスタイルで行ってまいりました。このようなスタイルも定着してきたかというところでしたが、JSIP2020 においては、新型コロナウイルス感染症の影響により、日本における模擬裁判の2を事前にアップロードし、ウェブ会議を活用してパネルディスカッションを行うという、これまでにない新たな開催形式といたしました。ご視聴いただいた皆様においても、事前のビデオの視聴や資料のダウンロードなど、新たな開催形式での実施にご協力いただき、おかげさまで無事に本プログラムを終えることができました。さて、今年のテーマの一つは均討論でありましたが、ご覧いただきましたように、模擬裁判については、すべての国において、均等侵害成立という結論になりました。 それぞれの国の均等侵害成立の要件は異なり、結論に至るロジックも、特に出願経過の参酌の点については異なるものでしたが、発明の保護と第三者の信頼、予測可能性の保護をどのようにうまく調和させていくかという問題意識には共通するものがあるように思いました。世界各国で共通の法的問題に直面するというのが知財法の特色ですが、今後も各国と緊密に情報交換や意見交換をしていく必要があることを改めて感じました。さらに、世界中で蔓延する新型コロナウイルス感染症の影響により、各国の裁判所も困難に直面する中で、どのように社会インフラとしての裁判所の機能を維持していくのかについて、インターネットを活用した各国の試みについて伺うことができたということは、知財分野に限らず、民事訴訟一般についての審理を考える上で、大変意義深いものであったと考えます。それでは裁判所パートにご参加いただきましたすべての皆様方に、改めて厚く御礼を申し上げ、裁判所パートの終了の挨拶とさせていただきます。誠にありがとうございました。
ありがとうございました。以上で第1部の裁判所パートを終了いたします。ライブ配信でご覧いただいた方にアンケートご協力に関するお願いがございます。本シンポジウム専用ウェブサイトにアンケートを用意しておりますので、ご協力をお願いいたします。アンケートはウェブサイトから直接入力することができます。それではしばらく休憩をいただきまして、第2部は9時55分から開始させていただきます。